The trial of Dr. Malachi Z. York was presided over by Judge C. Ashley Royal. Judge Royal was nominated by then President George Bush as a federal judge in the Middle District of Georgia. Prior to becoming a federal judge, Judge Royal was very acquainted with Dr. York and the Nuwaupians. The former Supreme Grand Master of the Nuwaupians, Roosevelt Richardson, affectionately called Abby Eli, received a surgical procedure at Oconee Regional Medical Center on September 25, 1997. A surgical sponge was left inside of him. This ultimately caused his untimely death. Abby Eli, a well-known resident of the Nuwaupian land, was the grandfather of 3 of Dr. York's children. After his death, the family of Abby Eli sued the Oconee Regional Medical Center. The legal representative for the Oconee Regional Medical Center was none other than Judge C. Ashley Royal. There was reason for Judge Royal to have bad blood against Dr. York and the Nuwaupians because Judge Royal, as an attorney, lost the civil suit that the Richardson family filed against the Oconee Regional Medical Center. Judge C. Ashley Royal should have never presided over the case of Dr. York because he violated Title 28 U.S.C. Section 455, where it states a judge should disqualify himself. In December of 2003, prior to the trial, Dr. York no longer wanted the Garland firm to represent him. Attorney Adrian Patrick was appointed to represent Dr. York 6 days prior to the beginning of the trial.
So he realized at that point, these people are waiting for the transcripts or the minutes so that the public can put it up. And so now they knew was waiting to get the transcripts. The transcripts we needed was the ones pre-trial, where the judge was making most of the biased statements, covering up for the prosecution, assisting the prosecution, and making outright derogatory statements against myself, where he took away my constitutional rights because he wouldn't give me a continuance when he knew I just got a new attorney, Adrian Patrick, a brand new attorney. He knew I just got him, and this man couldn't have enough time in 6 days to get the case together, and as I said earlier, and the prosecution had it for 2 years. So he, working with them, immediately said no, left this young man to work by himself. You follow? Wouldn't even let anybody assist him in the court. When he had, well, can I get somebody behind me to have a whole bunch of boxes? Because the Garland firm gave me 37 boxes and stuff that ain't nobody been able. They haven't even went to that dust on me. Can I get someone to come in the court, work behind me? He was told no. Meanwhile, the judge Ashley Royal allowed the prosecution to have Jelaine Warren, who was a part of the state case. You follow? Yeah, they have Thatcher from Washington, D.C. Then they had another woman up there named Tracy Bowen, right? But they had all of them there, and they was allowed to run in and out the court and assist Maxwell Wood, Moultrie, and Thatcher, giving them 5 other people sitting behind them with the press leaning over their shoulders. You follow? So they can assist them. So what happened is, the truth is now starting to come out, like they say. The chickens are coming home to roost.
Attorney Patrick asked for an extension because there was over 30 boxes of documentation revealed in discovery he had to review to properly represent his client, Dr. York. Judge C. Ashley Royal denied Attorney Patrick's motion. To show how Judge Royal showed further bias against Dr. York, on January 19, 2004, Judge Royal held trial on the federal holiday celebrating the birth of the greatest civil rights leader of our time, Dr. Martin Luther King Jr. This violated Section 6103, Rule 56, which states, "No court shall be held on a statute holiday." This was a blatant disrespect of not only Dr. York, but to all the African American people Dr. Martin Luther King fought for. It is clear that Judge C. Ashley Royal was biased against Dr. Malachi Z.K. York and should have recused himself prior to his trial.
During the pre-trial proceedings, Dr. York's attorney filed a motion for change of venue because of the negative publicity Dr. York received. It was deemed by the courts that the Middle District of Georgia and the Atlanta area were tainted. So the presiding judge, Judge C. Ashley Royal, moved the trial to his hometown of Brunswick, Georgia.
Before this, they planned on having an open court, make a big scene out of it. The judge was smart, so what he said was, I'm going to move this down to a town called Brunswick. So it happened that Brunswick is the same town that the Yamassee Native American Moors had their conflict with the Confederates, and he happens to be, Judge Ashley Royal happens to be a descendant directly of those Confederates. This is no coincidence, right? And he took it down to Brunswick, where he practiced law and lived for 20 Every time we would say somebody, he would say no, and then pick somebody else. He had already had these people picked. The people outside in the courtroom, because when you have a jury pick, you're sitting in a separate room. Outside in the courtroom, the people were gathered, over 200 people, waiting to be selected. As they were coming in, he would ask them, this is Ashley Royal, right? And we have the minutes of this here. Did you hear about the case? They would say yes. The whole purpose of pulling the jury is because they're not supposed to hear about the case, so they're not biased or prejudiced. They would say yes. Where did you hear about the case? I heard about the case from the Savannah newspaper. I heard about the case from the Brunswick newspaper. I heard about the case on the radio this morning. And did you hear about a guilty plea? Yes, I heard that the man pleaded guilty, so he must be guilty. He still put those people on the jury panel. After they came in and said they were discussing it inside the court before they came in. And this, about out of the 40 or 50 people that he did bring in, everyone said not one person said they never heard nothing about the case, or never heard nothing about the Nuwaupu, or never heard nothing about Malachi, or what they called every single one of them admitted to having heard something about this case. He still put them on the jury panel, and then he shuffled the jury panel in a way where it looked like there were some blacks up there, which would make it somewhere near a jury of my peers, but by the time it came down, those were what they call the sit-ins, and they were pulled off. And the one black woman who was left up there is the one woman who said this case is a farce, and I know it's going to get overturned, and I don't want to be a part of it. So she resulted in a hung jury. But what he did is he made all the juries anonymous so nobody could find them. So he could pick them and get rid of them so nobody can trace this out. So he set it up like that. So they moved it down there, but he used the excuse that he'd been monitoring the Nuwaupians for years as a judge in the Middle District, right? And he said they've been getting unfavorable press. We have this in his own motion. Unfavorable press for years. So now if we've been getting unfavorable press in the Middle District for years, how did Sheriff Howard Sales or Frederick Bright pull a grand jury out of what they would call a tinted environment? He said the only place I could find in the state, or outside the state, would be down in southern Brunswick. Well, southern Brunswick invited our lodge to come down into a parade, unbeknown to them, so he turned around and said that we passed out flyers, but not one of the people that was called into the judge's chambers, not one of them said that they saw it or read about it in a flyer.
Not only did he have the trial in his hometown, he handpicked an anonymous jury. Now, according to the courts, Judge C. Ashley Royal, the Middle District of Georgia, and the Atlanta area were exposed to information about Dr. York's case. Because of this fact, the jury pool from these areas were ruled to be tainted. This means that because of exposure to information about the case prior to the trial, the people from these areas could possibly have a biased opinion, damaging the possibility of Dr. York having a fair trial. That means when put in a situation where they had to weigh the alleged evidence against Dr. York, they would likely conclude Dr. York committed a crime because of the biased opinion formulated in their mind before objectively weighing all the facts. The interesting point everyone should know is the grand jury came from the same jury pool. They were presented with information in the grand jury proceedings used to determine whether the prosecution had enough evidence to justify the charges brought against Dr. York. When you consider that fact, during the arraignment of Dr. York, the lead investigator, Jelaine Ward, testified under oath that there was no evidence that Dr. York transported or caused to transport anyone.